If you've ever heard someone say that offshore trusts are just illegal or shady, they're wrong. Do scams exist? Yeah, absolutely. But not if you work with legitimate law firms and offshore trustees. Do your due diligence, ask questions, but the naysayers are completely wrong. But how you do it is really important. So let's quickly break down the case law. So US courts have upheld properly built offshore structures for literally decades. We have the Anderson case, the Solow case, the Grant case, which I've broken down before, and the Riechers case. These are very well established case law. These are your foundational cases. In Riechers, the judge even wrote that the trust was, quote, created for the legitimate purpose of protecting family assets. That's law, point blank, for decades. And the hybrid bridge trust takes that proven Cook Island protection and then integrates it into its core DNA. And it blends it with domestic control for tax simplicity with the IRS. Remember, the bridge trust is a Cook Islands trust, but it remains fully IRS compliant under Section 7701 and Section 671 to 677. And it only shifts offshore with human legal oversight through your attorneys as the trust protector if a real threat like a lawsuit appears. That's why I call it the firewall between your wealth and a broken legal system. It's transparent when it needs to be and bulletproof when you need it to hold up under fire, which it has successfully been in over 300 court battles over the last 30 years. It's really important to learn what actually holds up in court. That's why you always hear me say that you don't rise to the level of your assets, you fall to the level of your legal structure.